Hello, this is Dr. Tom Herskowitz, and we are in the final stretch, coming down to the last week and the last couple of chapters. This video is going to be talking about discrimination in employment, chapter 20. The learning objectives, we want to talk about Title VII, enforcement procedures, EEOC, things like that. Very important for you also to understand bona fide occupational qualification. That means that we call it a BFOQ. That means there are actually times that a company may discriminate. We'll talk about that in greater length in a few minutes. And then to understand the specific kinds of discrimination prohibited by Title VII, specifically disparate treatment and disparate impact. And finally, to discuss employment practices that can be challenged. The text has a timeline of all the various discrimination laws. You can see it's a very complex field, and we have attorneys that do nothing but deal in this area. Provisions of Title VII of the Civil Rights Act of 1964. They apply to employers with 15 or more employees, including labor unions. The purpose is to eliminate job discrimination based on, there's 5 categories: race, color, religion, sex, or national origin. You notice there's some other things missing, like Americans with disability and age discrimination. Those are separate laws. They are not part of the Title VII Civil Rights Act. And there are certain activities that actually allow discrimination based on a bona fide occupational qualification. Can a company discriminate between workers? Stop a second and think about it. Of course they can. A company discriminates between workers every single day. They hire somebody that can type better than somebody else. They hire a person on the assembly line that has better skills with different types of equipment. So discrimination per se is not illegal, but discrimination cannot be illegally discriminatory, and that's based on the race, color, religion, sex, national origin, and some other categories that we'll talk about. So we're talking about illegal discrimination, not just discrimination. Discrimination is prohibited in these activities when someone is fired, refusal to hire, compensation decisions, promotions, terms, conditions, and privileges of employment. All of those are subject to the scrutiny of a discrimination filter. The enforcement of the Civil Rights Act of 1964 is actually done by the EEOC, and it's the Equal Employment Opportunity Commission. They hold hearings, they obtain evidence, they're allowed to subpoena witnesses. They have many of the same rights of a court, and then they can also invoke penalties. Of course, the findings of the EEOC may be appealed to a federal court. 1991 amendments allow the recovery of compensatory and punitive damages, and the EEOC must wait 60 days if the state is already looking into it. An employee must file their charges of illegal discrimination within 180 days. So if a person has been discriminated against, they have half a year. If it's an ongoing discrimination, where it's happening on a daily basis, like disparate impact or a workplace harassment, then that 180 days starts from the last event. Okay, what are the different types of discrimination that are covered in the Civil Rights Act of 1964? Disparate treatment. Now this is when an employer intentionally discriminates against a person. This is focused on an individual rather than on just a group of people, maybe a group of individuals, but this is where the discrimination is intentional. Disparate impact is when the actions of a company have a discriminatory effect. There is no need for the company to be deliberately trying to discriminate. It may be that they have a personnel policy or a test that is inadvertently discriminating against one of the protected classes. And so that's disparate impact. And then retaliation is where a adverse action is taken against an employee because they make a claim of either disparate treatment or impact or something else. So be very careful when you have an employee that comes complaining. Make sure that they're not fired because of that, and be very careful they're not fired that is pretty close to when they do that, because it may look like it's a retaliatory dismissal. Okay, retaliation. There's a case, Thompson v. North American Stainless, in the textbook. Take a look at that. There was no question that the employer retaliated against Miriam Regalado. The question was whether Thompson, who was her fiancé and that was fired, if he had standing to be able to bring an EEOC claim. So take a look at that in the textbook. Disparate treatment based on race or color. Discriminatory practices for hiring, promotion are absolutely prohibited. There are no BFOQs for race or color discrimination. There's no business necessity. The law prohibits discrimination in employment conditions and benefits. That means promotions, vacations, even assignments within the company. There is never a reason to discriminate on race or color. Disparate impact is an example of personnel tests for hiring promotion, sometimes denying employment due to physical requirements of a person, maybe their height, something like that. Cases have found that that ends up being a discrimination against a national origin, because Latinos, I live in Belize, and the Mayans are here. All the Mayans are short people, and so you could be inadvertently discriminating against the Mayans if you had a height requirement, even though that person could do the job. Denying employment to unwed mothers, poor credit ratings, priority to present employees. And when you have a community of employees that is not racially balanced, then there may be a problem in giving priority to the existing employees, which really is following up with earlier discrimination. So disparate impact does not allow disparate treatment. And so we have the case of the Risi v. DeStefano. Very interesting case. Take a look at it. This city was just of New Haven, Connecticut. They were in a tough spot. They were going to get sued one way or the other. So take a look at that in the text. It's an interesting case of where disparate impact. The city decided to not promote the firefighters that had passed the test because there would be a disproportionate number of whites in that pool, and so they threw the test out entirely, which was then discriminatory against the people that had passed the test. So discrimination on national origin, that I talked about, for example, the height restriction could be a disparate impact on a ethnic group. Speaking a native language cannot be barred by the employer. However, there is a BFOQ that they can hire people that only speak English if the job actually requires it. If it's a help desk or an emergency desk, and they have to be able to speak with the people calling in. But if workers want to get together on their break and sit down and speak Spanish or Latvian or whatever in the break room on their own time, the employer cannot stop that. Discrimination based on religion. You may have a BFOQ. Employers cannot discriminate on the basis of religion in employment practices. You may have a bias, personal bias, against a different religion, Catholic, Jewish, Muslim, Protestant. You do not have the right in your business to selectively hire unless there's a BFOQ. And that is allowed by certain employers that, like churches and religious organizations, are allowed to hire their faith and discriminate against the other faiths. Discrimination based on sex. Sexual harassment is a hostile work environment. Pregnancy Discrimination Act, Equal Pay Act, sexual orientation is not yet in the federal books, but it's fast approaching and many states actually have it. Discrimination on the basis of sex or gender. The motivation, no matter how lofty, does not justify sexual discrimination. Johnson Control was a historical case that went to the Supreme Court, where Johnson Control did not allow women of childbearing age to work on the assembly line for batteries because they felt that the fumes would be dangerous, not only for the woman, which they could accept, the women and men could accept that danger, but it would be dangerous for the fetus or if she was pregnant. The court said that is not a reason. People have the right to make their own judgment and make their own determination. So it does not provide the employer with a bona fide occupational BFOQ just because they think it'll take better care of women. Sexual harassment, quid pro quo, is a harassment where the employees have been promised, the employee was promised benefits or threatened with loss if she did not give sexual favors to a supervisor. Something for something. That's the sexual harassment, quid pro quo harassment. And then hostile work environment is where the environment itself becomes so intolerable that a person cannot continue to work there. The defense to a hostile work environment is that the company has defined policies and procedures in place to report harassment, and they are actually being followed. These policies are published throughout the company. They cannot be sitting in the HR officer's desk. The harassed person does not notify the company of the harassing conditions. A company has a right to correct a hostile work environment. If the employee never notifies them, they don't have that opportunity. So they cannot come by and say they were harassed if they don't take advantage of the corrective action that the company allows. Lots of discussions of if and when a company is notified. Equal Pay Act prohibits discrimination on pay because of gender. Sexual orientation, Title VII does not prohibit discrimination based on sexual orientation. The word sex in Title VII refers to gender, either male, being either male or female. But some states and cities now forbid discrimination based on sexual orientation, and that certainly is an area of the law that's moving forward, and you need to be very aware of it and be very careful of it. Different practices that can be challenged, testing and educational requirements. Sometimes these educational requirements do not really are not really necessary for the job, and they end up creating a disparate impact. The test or requirement must relate to the performance of the job. You may have a requirement for a person to pick up and carry a 200-pound dead weight if that is a fireman or a subtype of job that they actually have to do that in their ongoing business. That may discriminate against women that don't have as much upper body weight. But that's okay because the job specifically requires it. But you cannot require all firemen to pass that test, because there are administrative jobs, there are other jobs that are very valuable and very worthwhile that women can do, and they don't have to be actually in the buildings dragging people out. So you have to be very careful when you start putting requirements in on jobs. Appearance requirements, there's no clarity with regard to it. It's different courts have gone both ways as to whether a person can wear a beard or not wear a beard. Obviously it gets into if they're claiming a religious reason for wearing it or a health reason, things like that. Affirmative action is federally contracting employees. This is sometimes called reverse discrimination. It's where a employer must hire a disproportionate number of women or racial numbers because of past discrimination. And that's a very big issue under discussion these days. Seniority systems are okay so long as they are really reflecting the longevity of the worker and not a hidden way of discrimination.